the matter of Kireeva and Bedzhamov.
Mr. Falk.
Thank you, Lord. Lord, I expect to finish shortly before 11:30, leaving me with a minimum of 15 minutes for my reply, so that we know where we're going. Yesterday I dealt with what was said about the trustee at the time of the freezing order to Mr Justice Arnold, as he then was. There was one footnote to add to that, just of the reference. It's in Mr Shobrook's first witness statement. That is at S/3/39, and I'll just read it, where leading counsel for Vneshprom Bank said to the court, in the course of argument, one can see that if there's any desire to intervene or make a point, then Mr Bedzhamov's trustee and his sister's trustee should be told. So strong inference that they were in contact with Miss Kireeva and she would know what was going on. Now can we turn to what was said when she did finally, very late, seek to intervene in these proceedings. And I just want to pick up the chronology, which we can do in the additional bundle, starting very briefly at tab 10, where on the 6th of January, my solicitors wrote to Keystone, pursuant to the freezing order, to identify the need to realise assets for funding, the intention at page 85 to sell Belgrave Square, the Clement Jewellery loan, top of page 86, and then the proposal to take a loan. So I don't need to take you to the detail of it, but that's when VPV were told, obviously subject to confidentiality proceedings in the freezing order, about it. Within just over a week, 8 days later, if you turn to tab 11, page 88, the investigation department of the Ministry of Internal Affairs of Russia, which had previously made an order seizing Belgrave Square in 2019, wrote on the 14th of January to VPB saying, earlier in the month, information was reported about the arrest imposed by the High Court of London on the real estate belonging to Mr Bedzhamov outside the Russian Federation. Due to the investigation of the criminal on the basis of Article 4, I ask you to provide information about all real estate objects belonging to Bedzhamov GI and his affiliates who have been arrested, otherwise restricted by the High Court of London. 5 days later, page 90, Vneshprom Bank responded by saying the claim was made in December 2018, 10th of April 2019 court to satisfy the application of seizure of property. Amongst the property is Belgrave Square, information obtained from the freezing order. No doubt it would be said by VPB who are not here, oh well, it had been mentioned in the public domain since then. But a very quick response to that, which led tab 12, page 96, on the 21st of January. So 2 days later,
Sorry, which yes.
The order for seizure, in the last bullet point, authorises seizure of the property of the accused Mr Bedzhamov. Decision can be appealed on appeal. If we then move, please, to, we'll come back to that bundle, to the supplemental bundle at S2 at page 19. This is with Miss Alieva's affidavit. Paragraph 93. Around the 27th or 28th of January 21, it was reported in the news that on the 21st of January the court had ordered the seizure of Belgrave Square. I have seen the Russian news and have also been informed by my English lawyers that it's been reported in the English language press. I've been provided by Mr. Kalizev. Mr. Kalizev is the DIA, i.e. liquidator of VPB, with a copy of the decision of the Tverskoy court. So that's what she says about that. Then if we go to S/3/21, 2 pages later.
Which page number?
21, my lord.
Thank you.
Paragraph 106. Since learning about the news of the seizure of the Belgrave Square property, I've approached the bank and asked whether, as a majority creditor of GB, is interested in funding these proceedings with a view to me seeking to recover the Belgrave Square property. They referred me to A1, who are the funds of the High Court proceedings. They have agreed to fund this application. So there we have A1 seeking to fund an application which, in effect, makes completely pointless the VPB proceedings. If we could then, please, go back to bundle A to tab 16, to the timeline as identified by Ms Kireeva's solicitors, page 119. As interesting for what it doesn't say as what it does say. So, in answer to queries on the 15th of March, we understand from our client she first learned of the seizure of the Belgrave Square property by the Russian court when she read about it in the press around the 27th or 28th of January. She obtained a copy of the decision of the Russian court at a meeting with the DIA on the 1st of February, that's Mr. Kalizev. 3, elliptically, periodically discussed with the DIA applying for recognition in this jurisdiction, but in respect of the application made, comma, at that same meeting, which I interpret as had previously discussed it on various occasions, but specifically discussed this application on the 1st of February, only understood the intention to sell the property on receipt of Keystone Law's letter of the 28th of February, and then how she discovered the address at which Mr Bedzhamov was living. So, all very rapid. Now, what is now said by Ms Kireeva is that she is entitled to all the assets, all the proceeds of sale of Belgrave Square, all the fruits of Belgrave Square, if not to the property, and that she can give directions to Mr Bedzhamov in relation to all his assets and presumably his liabilities. So whatever VPB is claiming is hers already as of right as trustee, without the need for litigation. She can control whether he spends any money on his defence or not, making the proceedings impossible and pointless, since she's made clear that she has no intention of helping him to fund his defence. If that is right, then it is extraordinary that the court has, since March 2019, not only imposed the strict regime and balances of the freezing order, but heard numerous applications. Mr Justice Arnold, I think, as you then were, heard an application in relation to the attempt to prevent us paying rent in Monaco. There was applications in front of His Honour Judge Keyser to vary the expenditure. There was an application to be able to sell Badrud's Palace. There was an application to the Court of Appeal in relation to his expenditure. At all stages, VPB knew, the court knew, the parties knew that Mr Bedzhamov had been made bankrupt in Russia. Nevertheless, everyone proceeded on the basis that the trial should proceed, the trustee wasn't coming, and that the proper protection for the assets was the protection of the worldwide freezing order. It is that protection which Ms Kireeva now seeks to destroy. And when Mr Justice Snowden asked in the course of argument in April this year, well, how does this interrelate with the fact that there is a bankruptcy in Russia and that VPB has submitted a proof in that bankruptcy and yet is proceeding in England. And it's at that stage that we get the document, which I'd like you to look at, please, at A slash 18, page 123. And this was sent by electronic means to the judge and to the parties, whilst Mr. Davis was, I think, on his feet in the middle of argument. And it's from Keystone, referring to our letter saying we weren't attending. Junior member of this firm has been in attendance. We understand a particular point has been raised during the hearing this morning relating to the treatment of any proceeds recovered by our client in the claim, and the court wishes to understand our client's position. Our client's position is that in accordance with Russian law, it is obliged to remit any sums recovered following judgment in the above claim to Mr. Bedzhamov's trustee in bankruptcy, or to distribute the sums amongst the creditors in accordance with the trustee's instruction, and intends to do so. Happy to provide further information. Well, that was not something that has ever been mentioned before. One may perhaps wonder whether my Lord or Justice Arnold at the freezing order would have perhaps looked at things differently if provided with that information at the time. Lord, can we now look in again in the that S slash 6 slash 9.
Is that an A reference, really?
No, I got the reference wrong. It is. One moment. Yes, it's S slash 6 slash 78. It's paragraph 9. I missed out a reference. And responding to what Mr. Shobrug of Mishkons had said about the proceedings of EPB, she says, I knew nothing about the proceedings having been issued, nor about the worldwide freezing order and search order being obtained, until this was reported in the news in April 2019. I was asked at the time by the DIA whether I intended to pursue any claims against GB abroad, and confirmed in my letter dated the 18th of March, attached to the affidavit, that I did not and had no funding to do so. Then again, if we go to page 81, paragraph 29, I reaffirm what I said in the affidavit about the dates of my knowledge of the proceeding of the property. I knew that Mr. Bedzhamov had assets here, but didn't know any specifics about the property until January 2021. I don't know how I could have identified property in the UK, found out about GB's ownership. Well, one asks the question, why not ask DIA? Further, had I been able to do this, and if I'd received verifiable evidence of the owned property, I would have had no option but to report it to the Russian court. Failure to do so would have been a breach of duty. But I would needed to have had clear evidence of ownership, such as land registry extracts. But of course, that was what was in Mr. Phillipson's affidavit. At S slash 18 slash 260, it's worth looking at. It's paragraph 11. She said, until this year, I've been without funds, been unable to work with the bank, in relation to its proceedings in London or the worldwide freezing order. I only found out about the freezing order in around April 2019 through a news report. Don't recall receiving a copy of it. The only information I received about proceedings is the information in the affidavit and correspondence relating to the hearing before the court on the 5th of March. As part of my preparation, I've also seen the affidavit of Mr Phillipson, so allegedly not shown to it by VPP, who has told the court in turn that it is holding any sums it recovers on behalf of the trustee. A most extraordinary state of affairs. At S2, I looked at that. One more reference I need to pick up. I think that's sufficient for those purposes. Now, it's interesting that there's no evidence whatever about any attempts to obtain funding in order to pursue proceedings in respect of property which she says she knew there was in England, nor become involved in or inquire about the proceedings which she says she knew in April 2019 were being pursued by VPB. But, Lord, there is the Baitler transaction. A/8/77, please. No, I mean, yes, A/8/77. This is a ruling in a case where Miss Kireeva was the applicant. It related to a transaction in which Mr Bedzhamov had sold property some years earlier, and she was trying to obtain ownership of it. If we turn to page 78, paragraph 2, we see this. Earlier, the bankruptcy administrator of Newey Bank, the DIA, had filed a claim with the High Court in London to recover monetary funds. During these court proceedings, the High Court in London obligated the debtor to disclose all his assets with a value in excess of £50,000. In the course of this disclosure of assets, the law firm Mishcon de Rea, in its letter dated 9th of April 2009, informed DIA, represented by TCB, of a number of the debtor's assets. Clause 10 of the letter indicates that Salamania, that's a company involved in Baitler, belongs to the debtor. Now, if you head to the next page, we get a request that the court acknowledges the title, and if you look at the enclosures, enclosure 2 is the 9th of April letter. It's signed by Miss Kireeva in person, and on the next page, page 80, is the asset disclosure order directed by this court at the WFO, and at page 81, first real property asset is Belgrave Square. And yet Miss Kireeva says she knew nothing about it until January 2019. If we then go to...
sorry, what's the date of the document that starts at page 77?
It's a 2018. Let me just find the...
Seems to be 16th of March 2020, judged by the index.
Yes. I think we see it in a moment. I'll come back to the exact date.
am I missing something? You said with some emphasis, and yet she says she didn't know anything until April 2019. That the Mishkon's letter at page 80 is April 2019. What am
I
I
should have
missing?
said April 21, and to January 21. I beg your pardon. In her, the 2 points. She says she knew about the proceedings in April 19, but she didn't know anything about the existence of Belgrave Square until January 2021.
Thank you.
Despite this, if we then look at tab 9, page 82, in the A bundle, Keystone, responding to complaints about why the asset disclosure letter revealed with the confidentiality of the WFO had been disclosed, provided their answer, 82. As you should be aware, the April letter was referred to Judge Jarman. Accordingly, from this point,
where are you now?
I'm sorry, bottom of page 82. In,
Which bundle?
oh, I'm so sorry, A/9.
Thank you.
As you should be aware, the April 2019 letter was referred to and included in the bundle in the hearing held in public on the 9th of July for H.H. Judge Jarman. Accordingly, from this point, it became a public document. On the 11th of March 2020, A1 provided a copy of the April 2019 letter to your client's trustee in bankruptcy. So there's A1, the funder of EPB and now the funder of Ms. Kireeva, providing her with a copy of the letter for unexplained reason on the 11th of March of 2020. The document was exhibited to the application on behalf of Ms. Kireeva, issued on the 13th of March 2020 in relation to transactions concerning property in Russia. So we can now see that it was the 13th of March 2020, the letter exhibiting that. Over the page, no restriction upon A1's ability to provide the letter to Ms. Kireeva. Now, at this stage, A1 was actively involved in the proceedings in this jurisdiction and was fully aware of the fact that Mr. Bedzhamov was spending for his legal expenses and defence of these proceedings in accordance with the terms of the freezing order, with notifications every time before any expenditure to Keystone, the proceeds of sale of Badrut's Palace, which, whatever its status in Russian bankruptcy or local bankruptcy, it was shares in a Swiss hotel. The proceeds of sale had been brought to England and were being spent to the knowledge of A1 and VPB. And on Malone and Friends' current case, those are all Miss Kireeva's assets, which shouldn't have been spent at all, and which, on their present correspondence, they're entitled to recoup. If we could now just look at this. Yes, S/6/81, a little earlier than the passage we got a moment ago. Her explanation, paragraph 27 of all this, Mr. Shawbrook placed much weight on the content of the asset disclosure letter, which I now understand includes details of Belgrave Square property. In answer to the question when I knew about the existence and value of the property, the letter was produced to my Russian lawyers for the purpose of assisting them in confirming within the Baitler application Mr. Bedzhamov was the owner of Salamania. I was never shown this letter, either when the English version was first produced to my Russian lawyers or when the Russian version was included as part of the papers in the Baitler application. I don't know why I didn't get it, but it may be for some other reason. So certainly her lawyers had it, certainly she signed a document which exhibited it, but she says she didn't know about it. And the reference, which I misspoke to, my Lord Justice Stuart-Smith picked up, we see her reaffirming at 29 again. No specifics about the property till January 2021. Now, so that's the trustee's current position, in which she effectively attempts, as we'll see in a moment, to stymie every possible effort of Mr Bedzhamov to defend the proceedings and or to survive at all. I want now to turn briefly to the unjust enrichment debt, because that is by far the largest amount in respect of which Miss Kireeva comes to this country. Could we look first of all, please, in bundle S at the DIA report? I may have done it again. Yes, it's in. Yes, it's the additional bundle. Additional bundle 1, tab 1, page 1. This page, 10 lines down, shortly before the bank's license was revoked, unusually large US dollar cash amounts were posted to the bank's vault, coming from additional contributions to the account of several clients made through a front office cash desk at head office. $43.8 million, and equivalent to 70 million rubles, and a joint group of representatives of the Bank of Russia agency reviewing the bank's financial situation, obtained information on possible debits from deposit accounts without client's account. As a result, a number of clients were compensated partially for previously unauthorized charges to their accounts. Beginning from the 26th of August until the above transactions, the foreign currency account had very small amounts, normally $24,000. The front office cash desk showed similar transactions and an additional contribution of 200 million rubles. The information about the debiting scheme through which clients' deposits with the bank were debited without their knowledge provides reason to believe that these transactions were partial set-offs of previous debts, but there was no cash delivered to the bank's cash department. So apparently repayment of money is falsely deducted, but no cash. The working group believe a fictitious vault cash balance of at least 3 billion rubles was then generated. On the 9th of December, the previously generated balance of cash in the bank's vault was used for transactions of loans to Mr Bedzhamov in the amounts of $30 million and 200 million rubles, and his sister in various other amounts. The diagram below shows the transactions. Therefore, by providing technical loans, Mr Bedzhamov and Ms Marcus may have concealed the fictitious balance of the cash account of the bank, which originated due to recording transfers to the accounts of natural persons. The cash department of the bank, in fact, never received the cash or issued it as loans, i.e., the $30 million and 200 million rubles were never ever paid to Mr Bedzhamov. The working group assessed the impact of transactions and financial position of the bank, taking into account the initial operations and so on. Fictitious transactions included in the register of the bank's creditors' claims, fictitious transactions to conceal shortages in the bank's cash have not been officially adjusted. Now, what was said about that by Mr Phillipson in his affidavit for the freezing order, we can see it A/3 at first of all pages 9 to 11. This is dealing with the claim for these monies, and at the bottom of paragraph 252, Mr Bedzhamov said DIA had not provided sufficient evidence he owed the funds in question, because the bank's records have been stored and managed in accordance with CBR procedures. His allegation that criminal authorities had dropped the charge from 200 million rubles was unsubstantiated. then various appeals. At the bottom of that page, on the merits, the GB appeal judgment held, although GB's lawyers appeared to have submitted the alleged loan agreement had never been concluded, the material of the case contained sufficient evidence of both the transfer of the funds in question to Mr Bedzhamov and their expenditure by him. The court therefore concluded the defendant received the funds unreasonably in the absence of a loan agreement and upheld the agreement. No mention to the court at any stage of what was found in the DIA report. That's why we get page 11258. In these proceedings, the bank does not seek recognition of the GB judgment as common law. Its reasons for not doing so are explained in detail in section NZ below in context of full and frank disclosure. Now, before I move to that section, can we just pause on those words? So, VPB, through Mr Phillipson, considering that they could, had this been a bona fide liability of Mr Bedzhamov, have sought recognition of the Russian judgment in this jurisdiction and enforced it, said in terms to this court that it did not intend to do so. No attempt to seek recognition. If we then go to page 19, paragraph 531, I've already referred above the unjust enrichment proceedings, stated one of the defences he raised was he didn't receive approximately 2 billion of the money claimed. He raised that defence in December 2016, shortly after the DIA, in its report, had reached the opinion that 2 billion was fictitious. Not mentioning there the fact Mr Bedzhamov was never provided with that report at the time. He only got it with the freezing order. These fictitious loans have been used to balance out fictitious cash deposits of certain customers who have been raising complaints about funds missing from their accounts. And then the bank raised a positive defence, a positive case, saying we believe the cash flow was sufficient. GB may say this inconsistency between the bank said to the Russian appeal court, the opinion it reached in its own report, demonstrates the bank was prepared to advance a case against him which it knew to be false. Therefore, the court should treat with caution the content of this affidavit, which has been made on instruction from the bank. He may also say this is consistent with a campaign to damage him, politically motivated. So, did they then seek to justify it? No. The bank would refute any such suggestion. The DIA was appointed as a liquidator in March 2016. Given the large volume of various legal proceedings for which it's responsible, in June 2016, DIA instructed a Russian law firm dealer to assist the DIA with claims against the debtors. The bank had on its balance, which included GB. DIA provided dealer with documents in respect to the portfolio of debtors, such as loan agreements and bank statements, in order to bring claims against such debtors to the dealer. At GB, dealer's task was simple, to draft debt claims against the debtors based on the documents they received, and to obtain final and legally binding judgments. Mr Matyushkin was a lawyer from dealer who had conduct. He did not have access to the DIA report. He proceeded with the claims and didn't take instructions from anyone at the DIA, who at any one time would have had external lawyers bring hundreds of claims, approximately 950 such claims. The external lawyers were given the mandate expected to get on with it. Then we have the timetable of the appeal. Then over the page 21, paragraph 537, the DIA has recently made inquiries of Mr Matyushkin as to how he came to advance a positive case in response to GB's defence. Mr Matyushkin confirmed he didn't have access to the DIA report. It was a mistake. That is a mistake which is the largest debt. The DIA subsequently provided the judgment to the party who had been charged with funding and managing the case prior to A1. That party did have a copy of the DIA report, nevertheless used the judgment to petition for GB's bankruptcy in Russia, GB ultimately being made bankrupt on the basis of petition filed by another of his creditors, put in a proof of debt for the full value of the judgment. Inquiries have been made of that third party. I understand from A1, the lawyer who worked on the matter at the time, Mr Erukin, and who submitted the bankruptcy claim, did not have access to the DIA report. This is because to carry out his duties in respect to the bankruptcy proceedings, he didn't require the DIA report. In light of the bank does not intend to enforce the GB judgment in this jurisdiction. Quite right, and no doubt the court at the WFO took comfort from that confirmation that it wasn't going to rely on such a dodgy claim. And yet that is the claim which since then the VPB and A1 have first of all sought to withhold the DIA report from the Russian courts when Mr Bedzhamov applied to use the document disclosed in the freezing order, which of course was in private, in Russia. That had to go in front of Mr Justice Morgan, references A/6/62. He ordered that we could use it in Russia. Nevertheless, the DIA on that occasion said no reason to change the judgment, appeal dismissed. And now the claim is brought for $3 billion, which include at least $2 billion, which are accepted by the DIA as fictitious. Ms Kireeva's answer to that, not a good one, is, oh, well, that must mean at least $1 million is all right then. A claim bought on a fraudulent basis is not good because of some bit of it which is tainted. It's also relevant to some of the questions I was asked yesterday, that although, as we've seen, the VPB did not seek to make a claim directly in respect of the unjust enrichment, they have made claims, what's known as a fictitious credits claim in this litigation, in respect of the same loans. And the position in summary is this. It is said in the VPB proceedings that there were 42 loan agreements. Those 42 loan agreements had credits applied to them by some fraudulent means, by some fictitious credits. The balance were unpaid and became the subject of the unjust enrichment proceedings. Mr Bedzhamov denies, and has pleaded his denial, that he entered into any of the loan agreements, including those the subject of the unjust enrichment claims. There is a substantial overlap between them, which we can see by looking at S/4/57.
I don't want to sound like Lord Justice Stoughton, but this is so small that I need a magnifying glass for it.
Well, you don't need to look at very much from law, because I'm going to tell you what's important. What happened was that VPB had a go at summary judgment. They exhibited Mr Phillipson's long freezing order affidavit and a one-page affidavit from a lawyer at Keystone, and said, can we have summary judgment for the fictitious credit amount on all of these 42 loans? And if you look at the left-hand box, those are the boxes, are the transactions which are in the unjust enrichment proceedings. And if you look below the line, there's the 30 million US dollars and the 200 million rubles. And on the right-hand side...
Sorry, where are the $30 million and the...
it's the left-hand set of box with columns in it.
Yes.
Right-hand column, credit balance. Below the line across the page, 2/3 down.
I see, yes.
We see 30 million US, and then 3 down, 200
Yes.
million euros. Rubles. Now, everything above the line, all those loans which are above the line, were also loans which are the subject of the fictitious credit allegations, where cases, one, did Mr Bedzhamov ever take out such a loan and receive any money in it, and two, did he receive any credit in respect of it? So there is already within the VPB proceedings the need to examine the vast majority of the loans, including the ones which are not the subject of the DIA acceptance that they were fictitious. So there is a substantial overlap. And that, of course, is all important because when one looks at the effect of recognition of Ms. Kireeva, she is seeking sums of which the vast majority are in respect of the unjust enrichment claim, which Mr. Phillipson, on behalf of VPB, has distanced himself from and told the court were effectively not to be pursued. And they just want to get it now through the back door. Lord, I now want to move on to the VTB 24 debt. Now, of course, I accept, and we can perhaps just look at this in the judgment in a moment, that the mere fact that one debt is challenged should not prevent recognition of the trustee. However, in circumstances where there are three debts, where one debt is a revenue debt, so unenforceable, the other one, the second one, the very much the largest debt, is at its lowest highly suspicious because it appears to be a fraudulent attempt to claim monies which were never received. And the third is challenged. Then in my submission, the court should be very slow to grant recognition until at least the challenge is resolved properly and fully. I accept that where there is at least one significant unimpeachable debt, then the court may well, absent factors such as delay, be prepared to recognize the trustees, but to limit the assistance so that the assistance does not extend beyond the unimpeachable debt. Now, in this case, the VTB 24 guarantee was a guarantee which it is said that Mr. Bedzhamov had given in support of a loan to his sister. It's common ground that Mr. Bedzhamov pledged certain lands as security for that loan. Those lands are in the process of being realized. There is a dispute about whether they and other securities will satisfy the liability or not. Nobody knows how much is outstanding. But it is said that there was a guarantee that he signed in addition. My Lord, in bundle S, tab 8, at page 134, within our skeleton argument below, and I say this because my own friend says we never really argued it, we first of all sought to dismiss, perhaps go back to page 134, to dismiss the recognition application on the basis of non-submission, then because the real beneficiary is VPB, then because it's pursued the objective of stifling Mr. Bedzhamov's defence and grounds of justice, delay, unfairness, oppression, safeguards. And then we said this, 8, if the court does not dismiss the application on the grounds identified above, it's submitted the court can nevertheless dismiss them in limine, cogent and uncontroversial evidence, the principal creditor's claims tainted by fraud, manifestly inaccurate, etc. And then this at 10, if the court is not persuaded to reject the recognition application, set aside application now, either on the grounds they're unsustainable as a matter of law, or the way Ms. Kireeva's delayed and brought them in as an abusive process, it will plainly be necessary for the court to give directions for disclosure, expert evidence and trial, probably with cross-examination of factual expert witnesses, in order to decide the relevant disputed factual issue. There are, within the document served, a document in which Mr. Belchik makes clear, and the judge indeed refers to it in his judgment, to the fact that the claim was defended in Russia on the grounds that it was a forgery. That's S/12/166. If we start at 165, paragraph 14, Mr. Bedzhamov, the trustee, didn't sign the guarantee, unaware of its existence. He requested a court-appointed handwriting expert, standard procedure in Russia. Application was successful. 15. However, in order for the examination to take place, the Russian court required Mr. Bedzhamov to provide sample signatures in person to the court. That requirement that he should attend in person could not have been complied with, basically because if he complied with it, he, a sick man, would have been put in prison. The only way in which he could prove it would be by, in effect, submitting to what he says is a false imprisonment. There has been an attempt in this country to extradite Mr. Bedzhamov to face these charges. That's been dismissed.
Can I just clarify one thing, Mr. Fenwick?
Yes.
Since this is now really one of the central planks of your case, where in your skeleton before Mr. Justice Snowden was there any reference to the VTB 24 alleged forgery? I may have just missed it, but the passage you read out before spoke of the difficulties with the VPB loan, but I'm not yet identified where in your written submissions for Mr. Justice Snowden you relied upon the forgery of the VTB 24 documents as a basis for refusing recognition.
My Lord, I understand the point exactly, of course. In his first witness statement on the 23rd of March, which is at S5, at page 71, Mr. Belchik gave evidence that was no personal guarantee, and the document suggesting otherwise was a forgery. So that was in the evidence.
Sorry, which paragraph 49. Yes, that's it.
Yeah. So that's in the evidence. In my submissions, tab 8, page 135, I referred to the need for a full hearing with cross-examination of factual and expert witnesses.
No, I'm sorry, Mr. Fenwick. My question was very simple.
Yes.
Where in your written submissions do you refer to or rely upon the alleged forgery of the VTB 24 documents as being a basis for non-recognition?
I don't. Why not? It wasn't there. Remembering, and that's my fault. I mean, it's clearly there in the evidence that it's a forgery. I'm clearly saying here, I mean, the battleground for this was an urgent sale of Belgrave Square being thwarted by the trustee. The purpose of the expedited hearing was to see whether there was a claim to Belgrave Square. Recognition was, of course, part of that, and our submission was you can either dismiss recognition in limine, or we need to have a hearing of the VTB 24 application because of it, and that will need expert evidence. So if it's not there, and I can't invent it when it's not there, it does not mean when in our submissions we made clear that it was a forgery. Mr Bedzhamov put in a witness statement confirming it was a forgery.
But that was on day 3 of the hearing.
On day 3, yes.
Am I right in understanding that that's when Mr Belchic's third statement came in
Yes.
as well?
Yes.
Did the other side object to the third statement going in? Thank you.
So the material was before the court. Now, if we then go to the judgment and see how the judge dealt with it, it starts at core 7, page 116. And the earlier section 155 and 156, where he deals with the question of one impeachable debt or unimpeachable debt. And he makes the point at 158, my Lord Justice Stuart-Smith has made to me, didn't suggest in the written submissions. However, in oral submission, this defendant did seek to make the argument. Then set out the secret. I submitted it was forwarded on the basic complaint of forged signature. And then a comment on the evidence, which I've drawn attention to. Then English translations of 2 documents. Except, of course, this is similar fact evidence, that Miss Bedzhamov's partner was alleged to have signed a document in the VPV proceedings, which was found by the Russian court to have been a forgery. Miss Panina, another person, again a forgery. He says those are unpersuasive, they are only separate proceedings, don't have anything to do with VPV 24.
The highest you could put them is they show that people behave fraudulently.
I'm sorry?
The highest you could put it was that they go to evidence that people do sometimes behave fraudulently in these sort of claims.
Yes.
Full stop.
And that banks, which are being managed by the Russian state through the DIA, which is also a significant shareholder in VTB 24.
So it goes to plausibility, but no more.
Yes, no more than that. It doesn't prove it. I mean, I freely accept that I did not have material on which I could, at that stage on the balance of probabilities, demonstrate that it was a forgery. But that wasn't the test which the learned judge should have applied in circumstances where the matter had been brought on urgently in order to deal with Belgrave Square. We had made it plain that we had a challenge. There was sworn evidence that it was a forgery. There is evidence that forgery exists. For the judge to say that we should, at that stage, at that urgent hearing, intended to deal primarily with Belgrave Square, have produced and been able to produce our full case when we were given a fortnight to produce our evidence, was in my submission the point at which the judge fell into error.
The fortnight being between the 5th of March and the 22nd of March when you were obliged to serve your evidence, is that right?
Let me, I want to get those dates right. I think the directions were given. It's A17, page 121. Ordered on the 5th of March, expedited 1 day hearing of the recognition application to be listed for High Court Judge, date to be fixed in first week of Easter term, response to file and serve his evidence in response, if so advised, 4 p.m. on Monday the 22nd of March. 17 days from the 5th of March.
So why would Mr Bedzhamov have been in any difficulties in filing a witness statement saying this document's a forgery, with it given that he's here?
Oh.
That's something within his personal knowledge, if it's true. 17 days to do it? Why is that some kind of unbearable rush such that his failure to do so could not be taken note of?
Oh, no, I understand that. Mr Belchik gave evidence about it, of his instructions. I accept with no evidence of Mr Bedzhamov. There couldn't have been expert evidence in that time, not least because the expert evidence is not, the original has never been produced. We've asked for it since, and we've
But
been
that's not
denied.
right, is it? Because handwriting experts frequently produce reports on the basis of photocopies.
Yes.
And it depends, of course, on the type of forgery you're dealing with.
Yes.
If it's a completely different person signing, handwriting experts can often pick that up from comparison of photocopies. If, on the other hand, it's a transposition of a genuine signature onto a false document, then you may need originals. So it depends on the nature of the forgery.
It does. You also can see the document itself, S 11, page 161.
I thought the reason for not
Sorry?
having an expert's report was absence of funds.
Well,
Have I misremembered that?
he had no funds, so but you couldn't get very much in that time anyway. I mean, here we are. Mr. Bedzhamov has no money. He's now faced, when he thinks he's preparing for trial, with having to prepare for this very large application by the trustee, and combination of funds, time, and concentration on Belgrave Square means it wasn't done.
Can I just understand that a little bit better, Mr. Fenwick? He has what, in most people's eyes, would be regarded as quite a generous allowance for normal living expenses.
He had.
He has. My experience, limited though it may be, of getting experts' reports on things like handwriting is that if you gave someone £5,000, you would be doing quite well. Now, you may get a report out of that which says, I can't give you a definitive view without seeing the original, and that would be understandable. But in the context of the sums of money that are being spent generally, I find the assertion that absence of funds prevented obtaining an expert's report difficult to understand.
Well, my lord, you say he had a generous allowance. By this stage, the funds available to him had run out funds before. His lawyers were working on credit. The availability of resources to do so is limited. I accept.
And does that remains the position today?
It remains.
Unless and until further assets are released to enable funding?
Yeah, yes, I make no bones about the fact that I am here in the hope and expectation that funding will be released. But without it, there are a lot of very empty pockets. And here you have, I was showing you at page 161, it is a short form signature, quite difficult to deal with. Mr. Justice Snowden made the point, in my submission wrongly. Well, Mr. Bedzhamov had plenty of time between 2016 and 2021 to get an expert report on this. But of course, until the trustee surfaced, there was no need, because Mr. Bedzhamov wasn't in Russia. All his Russian assets have been expropriated by the Russian state or seized by the trustee. And what he's been focusing on is a VPB claim. So we say that the learned judge should not have recognised the trustee at this stage without being properly satisfied or giving a proper opportunity to deal with the genuineness or otherwise of the VPB debt. We have already, and this is in A/1 33 at page 272. Put in evidence, this is...
Could you give me that once more, please? Reference.
I'm sorry? Yeah.
Could you give the reference?
Yeah, it's A/33/272.
Thank you.
And in relation to those credit transactions which form the unjust enrichment proceedings and the fictitious credit, Mr. Bedzhamov had, by the time of this witness statement, this is after the hearing, it's in September, obtained preliminary views of a handwriting expert that the signatures of Mr. Bedzhamov on those agreements which existed showed a consistency which would not normally expect to be found on a number of signatures written on different occasions. Physical inspection of the documents, that's the originals which we had got only in September, led to a number of additional points of inquiry. Ms. Marsh has produced a final report which has been served, in which she indicated that there was strong evidence of forgery. So that is not
the
VTB
VTB
24
loan
VPB,
is it?
Sorry?
Not the VTB loan document.
No, it's not. But it is another entity controlled by the DIA, the Russian authorities, and it is relevant. So, Lord, what is the effect of allowing recognition to remain if your lordships were not with me, that it should be set aside? What you say should happen is it should be set aside, and because all these matters are going to be dealt with at the trial of this action, which would have been in January had it not been derailed by the trustee, that is the time at which these matters should be canvassed and dealt with.
Has January gone?
January has gone because of this. Because Mrs Justice Falk recognised that without any means of funding and with effectively everything challenged, it couldn't happen. So she is actually at the moment organising a directions hearing which will be held in the light of your lordship's judgment to see where we go. Because if we win or are in a position to realise assets in order to pay fees, there will be a trial. If, on the other hand, the trustee is successful and owns everything, then the entire shebang will have been a waste of time and money.
Because he won't be represented. Because he won't be represented.
No, because everything that VPB have been claiming would belong to the trustee as a result of the bankruptcy in 2018, recognised by this country.
Why do you say that everything on this aspect would be gone into at the trial? I mean, this is the VTB debt, really, not the VPB debt. So why would the trial judge be looking at the VTB 24 debt?
No, the VTB 24 debt, £3 million, perhaps £3.5 million, would not be, unless one's looking at issues of forgery generally with handwriting experts. I accept that. But the rest of, the bulk of the trustee's claim will be the subject of it. And of course, what emerges in relation to the way Mr. Bedzhamov has been treated, he will either be found to be a crook, or it will be found these documents have been forged, and this is a dishonest claim being made against him. If it is a dishonest claim made against him, then that will have its own impact on the allegations in respect to VTB 24. Mr. Bedzhamov is, of course, entitled in its jurisdiction to challenge a foreign judgment on grounds of fraud. It would normally be done by proceedings, and there would normally be a proper process. It would not normally be done on a summary basis in the sidelines of a Belgrave Square application.
But if we were with you and decided that the judge had made an error,
Yes.
which required his order of recognition to be set aside,
Yes.
then we would have to face the question, well, how is that now to be dealt with?
Yes.
And in one sense, there might be a logic in giving it all to the trial judge, which wouldn't bring the VTB 24 loan into the VPB claim, but would provide a forum for all these matters to be resolved.
Yes.
But on the other hand, it might be said that given that the VTB 24 debt is a completely separate issue, which is relied on independently by the trustee, actually what you should have is a much smaller trial of that issue in advance of the VPB claim.
Yes, I understand that. Had we been about to go to trial in, if Mr Justice Snowden, shortly after April, had handed down a decision, or as he did hand it down in September, with a trial in January, it would, in my submission, be obvious, as we submitted at the time, that you should do it all at once, because there would be no particular benefit in having an additional early hearing.
Since the January trial's gone off anyway.
Since the January trial has gone off anyway, then one could have a separate trial of the VTB 24 issue.
And the VPB trial is estimated for 40 days, did you say?
40 days at the moment, I think. As always, one prefers to have enough time. I think it will be between 30 and 40 days. But it's certainly going to be a substantial trial.
With
the advantage, of course...
With the advantage of not really knowing much about it, 40 does sound luxurious.
Yes. I think 30 is probably where it will be. As you know, there will be a number of experts. We don't know how many witnesses the claimants will provide because the dates of witness statements never happened. But what I do say about recognition now, whether your lordships are with me and set aside the recognition and direct that the matter be dealt with either in the earlier hearing or in a composite hearing, and bearing in mind the amount of money to be spent and the resources which are scarce, one would submit that unless there's going to be a significant delay, it could be heard at the same time as the VPB trial, but obviously in a discrete section, so it wouldn't require VTB or the trustee to be there for the whole thing unless they wanted to be. So it could all be dealt with together.
I don't understand why it's in anybody's interest to have the two heard together, given that they're completely discrete issues, and given the potential significance, if indeed it's concluded that the VTB 24 debt is a good one, and therefore the trustee ought to be recognised.
I understand that. Of course, that then leads me on to, and I've made my position clear, and either way would provide Mr Bedzhamov with access to justice, whichever route was taken. But whatever is to happen, at the moment, what is happening with the trustee is that Mr Justice Snowden treated this, as you've seen, and we can see it in the judgment. I'm very conscious of using up all my time, so I'm doing it as quick as I may. Mr Justice Snowden treated this, as it then was, as an application for assistance over Belgrave Square. Having decided that Belgrave Square was an immovable and not available to the trustee, he recognised the trustee but gave no further assistance, and indeed refused any further assistance. As soon as the judgment was handed down, up popped the application for the proceeds of sale, up popped the application for the after-acquired movables, up popped the application against Clement Glory, a further unilateral notice was imposed, and even now, the case being put forward by the trustee and correspondent is that every single penny which comes into Mr Bedzhamov's hands is hers, including, for example, costs which have been ordered to be paid by Mrs Justice Falk have been paid to my client's firm, lawyers, Mishkon Daria, and are held in their client account. And that said, that's the trustee's money. and if you pay it out, we will claw it back. It will be said that if we win and get any cost in this court, that belongs to the trustee too.
So presumably that position effectively freezes those costs in Ms Kondraya's client account.
Well, it doesn't.
Effectively.
It effectively places them on full risk. This trustee is not prepared to seek an injunction. She's not prepared to fortify it. So what she does is to lodge unilateral notices and do things which put lawyers in fear that they may be held in knowing receipt. So it's impossible to continue. And what we say, in summary, and I'll have to finish here, but I think it covers my submissions, is that if this trustee is allowed any form of involvement, whether recognition or otherwise, whether by right of immovable or as proceeds if Mrs Justice Falk so decides, or otherwise, having left the matter to VPB, its agent, as we're now told, with the freezing order, and then the regime of the freezing order which permits my client to spend money as permitted by that order on legal expenses and living expenses should not be prevented from continuing. He should be permitted so to do. And any attempt to try to prevent that happening and prevent my client having access to justice has been lost by the conduct of VPB and the trustee. Otherwise, it's all a complete waste of time. And that protection is, in my submission, needed. Indeed, yesterday, I tell you in the correspondence, my client underwent heart procedure, for which it was said that any payment to the doctors which had to be made in advance of the procedure would be clawed back by the trustee. So this court needs to do something, unless this trustee is to make the claim against Mr Bedzhamov one that he cannot defend.
I don't understand that, because what can we possibly do? I mean, your peroration is very eloquent, but what can we possibly do? Because let's assume we're with you on your appeal against recognition.
Yes.
As you rightly accept, the consequence of that is there will have to be a trial.
Yes.
And whether one does it together with BPB or separately in advance, it still remains the case that the matter would still have to be tried. So therefore, the court would have to proceed on the basis that it may yet be the case, even or if you are successful on your appeal, that the trustee is ultimately recognised.
Yes.
And in those circumstances, the immovables rule, even if assuming that Mr Justice Snowden's ruling on that is upheld, will not be a bar to any claim in respect of movables. And so you're going to be stuck with the problems that the trustee's attitude causes, you say, come what may.
Well, there is an issue as to whether after acquired movables fall within it, which hasn't been, that is to be canvassed before Mrs Justice Falk. And I accept that if that holds that he's entitled to all movables, then the question of whether or not he has a proprietary claim to it arises. But nevertheless, the court can, in my submission, order that Mr Bedzhamov be permitted to spend reasonable sums on the defence of these proceedings and on living expenses.
But that's only going to be a practical proposition if Mr Bedzhamov can sell Belgrave Square in the face of the current uncertainty caused by the recognition application.
Well, the position on Belgrave Square is that the trustee was given time to object to its sale. We say you should not set aside the variation order. She inspected the property, appointed a valuer. We asked if they challenged the value. They haven't said a word, either yes or no, so their time for objecting has passed. We can now sell it for £35 million. Proceeds of sale will go into the client account. It will then be a matter of notification to VPB, and it can be to the trustee, and Mrs Justice Falk can, in case of a dispute, determine whether or not funds can be released.
Are you telling us you have a buyer?
We have a number of interested parties, but nobody's going to proceed until we have some certainty on the immovables, because if it's hers now, then we obviously can't sell it. Clement Glory may, and then there'll be a spat between Clement Glory and the trustee.
All right.
Unless I can assist you further, there's my...
Thank you very much. Mr Davis, under the timetable, you're entitled to 1¼ hours, and you're certainly going to get 1¼ hours. It may well be that Mr Fenwick, in the way of proceedings in this court, wouldn't actually wish to say anything much by way of reply anyway. But let's leave over the question of whether Mr Fenwick is given any chance to reply at the end of your 1¼ hours.
Do we need to give the short?
My Lord, I'm conscious of the transcribers.
Yeah, quite right. So your 1¼ hours will anyway take us past 1 o'clock. But we'll rise now for 5 minutes.
Lord, I'll do my best.
Thank you very much.
Court rise.
Interesting. Right. Well, the idea of getting them engaged now on other matters is a bit different. Right, okay. Cool. Do you just want to...
Court rise.
Mr Davis.
Lord, I'm afraid going back into that very arid and dry garden is inhabited by section 426 and the Dicey Rule 217. By way of responsive submissions to those made to your lordships by my own friend Mr Robbins. And for this purpose, my lords, could I ask you to have open two documents? The first is Dicey behind tab 81 in the authorities bundle 4, page 1757, which we looked at the very beginning of my opening, which is how it appears in Dicey. And secondly, I'm afraid in the same volume, I'm sorry about this, if we could please have open, as it were, at the same time, section 426, which you'll find behind tab 77, about 3 pages from the back. Now, Mr Robbins made submissions to the effect that section 426, subsections 4 and 5, the assistance provisions, constitute a statutory exception to the Immovables rule. In our respectful submission, it emphatically does not, for many reasons. First of all, you only have to read Dicey Rule 217 to see that the text of the rule itself make it absolutely clear that the Immovables rule exists notwithstanding 426. And the way on page 1757 of Dicey, where the rule itself is articulated, the way they do it is that they say, subject to the effect of the insolvency regulation, it's relevant, an assignment of a bankrupt's property to the representatives of his creditors under the bankruptcy law of any foreign country, and please note, other than Scotland or Northern Ireland, I'll come back to that, is not and does not operate as an assignment of any immovables of the bankrupt situated in England. But in a proper case, the English court may authorise the appointment of a receiver of the rents and profits of such immovables. Now, if you go to section 426 itself, you'll see that it's in terms of its operative provisions, two parts. The first part is section 426, subsections 1 to 3. And they relate to, speaking loosely, Northern Ireland and Scotland. And they are the subject of Dicey's Rule 215. And that is a statutory exception to the Immovables rule. I don't know whether your lordships received copies of Dicey's 215 from us this morning.
I haven't received anything this morning, but I dare say...
I'm so sorry, I have some hard copies here. We have obviously given to my own friends.
Yeah.
I'm sorry to weary you with more paper, but this is an important point of principle. May I suggest that the document I've just handed up, it's not perfect, but be inserted at the end of tab 81 after the text to Rule 217, even though it's obviously Rule 215. And if one looks at Rule 215, you'll see the statutory exception for Scotland and Northern Ireland. I'll just let my lords read Rule 215. And could I invite you at the same time to look at section 426, which I asked you to have open behind tab 77, which gives you the text of section 426, 1 and 2. Sections 1 and 2. They are the intra-UK provisions. And very briefly, sections 1 and 2 are about enforcement, shall be enforced. And 4 and 5, which are not intra-UK, all the other courts, and they include the UK, but they're all the other relevant courts and countries, are about assistance. So subsections 1 and 2 are about enforcement, 4 and 5 are about assistance. I'm going to address Lord Justice Arnold's point about the last words in subsection 5 in a moment. Could I invite you to look at the qualification in subsection 2? Nothing in subsection 1 requires a court in any part of the UK to enforce, in relation to property situated in that part, any order made by a court in any other part of the UK. So there's a qualification even to the exception in relation to intra-UK enforcement of mutual enforcement of bankruptcy orders. And if one then looks at the note that I've just handed up within DICE at paragraph 31-071 on the second page of the photocopy, you'll see the learned editor's commentary in relation to that qualification. Whatever Scots or Northern Irish law might say on the matter, the English court is not required to enforce the order of a Scottish or Northern Irish court as far as it relates to property situated in England. But the provisions about mutual judicial assistance and the possibility of orders under 3, that's irrelevant because no such orders have been made, are likely to prove of benefit to Scottish or Northern Irish trustees who seek to obtain effective title to property situated in England. So, in summary, subsections 1 and 2 are a statutory exception to the Immovables rule, subject to the qualification in subsection 2. They are the only statutory exception to the Immovables rule, as I'll come to show in a moment. If, in an intra-UK dispute, the English court, as an example, does not wish to recognise the vesting in England, vesting in Scotland of English real estate, it may do so under subsection 2. But then it goes on to assistance in 4 and 5. So notwithstanding the fact that the Immovables rule will be recognised as remaining in place as a matter of discretion, how else can I help you? That's the position in Northern Ireland and in Scotland. And you'll notice that the editors of DICE make it absolutely plain that Rule 2 and 5, the text of it, that operates as an assignment of such representative of bankrupts, immovables land and movables wherever situated. By contrast, Rule 217, of course, is the other way around. And so my learned friend Mr Robbins was able to make his submissions that he did because he ascribed to the Immovables rule features that it does not have. The Immovables rule is no more than, in this case, that the Russian bankruptcy order and statute do not ipso facto pass title. You must go to the lex situs for that. And I'm going to call the Immovables rule from now on the ipso facto rule, just so that I can emphasise and ask your lordships to keep in mind its narrow parameters. We see in all of the case law that that is what is going on.
Yeah, and this is because it's, you say, it's a rule for choice of law.
It is.
It tells you what law to apply.
Yeah.
And it tells you that you must apply English law. And the result of applying English law is that there's nothing which assigns title.
My lord, absolutely. That's the point. The ipso facto rule, as I'm now calling it, does not operate to airbrush the immovable from the Russian bankruptcy estate. It doesn't airbrush out the trustee's duty to get the immovable in, or the bankrupt's duty to deliver it up. And my lords, here's the point. Could I ask you to cast your minds back to Lord Collins and his 4 methods of giving assistance? They are all subject to the ipso facto rule, even the CBIR. Not one of those methods. Well, I'm ignoring the EU reg for the moment because it's for lots of reasons. But let's just say the other 3. Not number 1, which is his 426. not the CBIR or number 4, which was common law. They're all subject to the ipso facto rule, and they're all means of either mitigating against it or, more colloquially, sidestepping it, as to use the phrase in the textbooks. And so, my lords, when we look at the text of 4265, and my Lord Justice Arnold yesterday made some very brief observations about the reference to private international law. What that means is that when in a bankruptcy, a court in this country is asked to look at immovable property here, it must do so having full regard to the effect of the ipso facto rule. That, in fact, is why the foreign insolvency practitioner is here, because of the ipso facto rule. And
So can I just put that in my own words? So what you're saying there is that what the last sentence of subsection 5 means for our purposes is that the court must take into account, have regard to the ipso facto rule. And so therefore, if I've understood you correctly, the court must take as its starting point the fact that there is no assignment of title.
absolutely.
And exercise its discretion on that footing.
That is precisely what is happening in a case such as this. Far be it from being an exception to the ipso facto rule, 426 is a gateway for getting around it, for mitigating against it, for sidestepping it. And so the fundamental premise of the entirety of my learned friend's submissions on this is, with respect to him, not correct. Because he went on to say, if you haven't got a statutory exception, then I'm afraid at common law you're stymied, tough luck. And his premise is just wrong. The common law and section 426 are the same for these purposes. They're different in other spheres, but here they're the same. And can I just demonstrate why they're the same? Let us suppose that Russia is a relevant country for the purpose of 426. I would be in a better position in two respects only. First, I would have a higher expectation of assistance. It's almost sort of guaranteed, subject to extraordinary circumstances. And secondly, because it's a request from a relevant country, I wouldn't have to worry about submission and all of those sorts of issues, domicile. Because that's not how the gateway works. Those 2 points aside, we would be in exactly the same position. In each case, the ipso facto rule applies. In each case, it's observed and never breached. No court says, I recognize that you have had title vested in you because of your Russian order and statute.
Can I just rephrase that second point to see if I've understood it correctly? What you're saying is that, as far as the second point is concerned, section 426 does not depend upon common law recognition. You can simply proceed to say, here I am, I'm a relevant country, I'm a trustee, please give me assistance. Whereas common law, you've got to have a first step of saying, I'm not a relevant country, therefore I have to show common law recognition.
Oh, yes. My Lords, it is right that you should, when looking at all of these cases, reflect on the difference between corporate insolvency and bankruptcy. Because in corporate insolvency, it is more complicated as to what that phrase in subsection 5 might mean, have regard to private international law. It raises issues as to which regime, perhaps which insolvency regime should apply and all those sorts of things. But with the immovable rule in bankruptcy, it's binary and it's clear. It's a very straightforward Rule 217. And the question is, can you get round it by assistance through subsections 4 or 5? That's all there is to it. If you have any doubt about that, my Lords, you've only got to look at Rule 215, which is why we sent it to you, just to have a full picture. And in respect of paragraph subsections 1 and 2, there's plainly the only exception to the immovables rule. And, my Lord, the point here about the difference between subsections 1 and 2 on the one hand and 4 and 5 on the other, as most things have been, was dealt with in Rubin. And if your Lordships go behind tab 63, my Lords, I'm going to give you the time. I'm just going to give your Lordships the references. In argument on page 243 of the report, Mr Knowles, Queen's Counsel, at letter D of 243, made this very point. I'm so sorry, it's the top of the page, I should have said. It starts at 242H and it ends at 243B. And he makes the difference between enforcement in the first two sections and assistance in the next two. And that's just for context, because you actually have in the judgments of Lord Collins at 151 on page 281 of the report. 152, I'm sorry, paragraph 152 on page 281. He says, second sentence, in my judgment, subsections 4264 and 4265 are not concerned with enforcement of judgments. By contrast, 1 and 2 deal with enforcement of orders in one part of the UK, in another part, and for expressions the enforcement of such orders shall be enforced, etc. 4 deals with assistance, not only for foreign designated countries and so on. And they're doing very different things. Before leaving section 426, we feel that your Lordship should see, at least, for reasons that I think will become clear, behind tab 57 in file 3 of the authorities bundle, you've already looked briefly, I think, at HIH, another decision of the House of Lords, a 426 case. Could I show your Lordships what is said by Lord Hoffman on page 861, paragraphs 29 and 30, about the words rule of international law as it appears in section 426(5).
Sorry, paragraph.
It's paragraph 29 and 30 on page 861. This is different from the issue on which the House of Lords was split. And that issue was where there was a common law jurisdiction to remit the assets to Australia to be exposed to a different regime for distribution. In this respect, on the facts of this case in corporate insolvency, Lord Hoffman was identifying modified universalism as the relevant rule of private international law. Lord Walker agreed with that, paragraph 63, as did Lord Phillips at paragraph 43. That's an aside in one sense, because they weren't dealing with bankruptcy or immovables, but it does show you that modified universalism is a form of private international law, and that it plays a part as much in 426, 4 and 5 as it does in common law. I'm conscious of the time, and so I want to do this, I hope you'll forgive me, quite quickly, but I think it is essential that I show you, I'm afraid, yet again, just a handful of the cases which, without exception, all endorse the fact that these assistance provisions are subject to the ipso facto rule and, in fact, are invoked because of it, because they have to get around it. They are not an exception to it. The best and quickest way of doing it, if I may say, is to look at the very full judgment of Justice Drummond in Radich, which we looked at yesterday, behind tab 44. And the reason I'd like to offer this to you is that he also, in the same process, explains what was happening in Osborne in a way which I would very respectfully suggest is both accurate and full. So we don't need to go to Radich for anything other than the analysis. It's behind tab 44, and the passage in question is just before the one that was read to you by my learned friends. And what he says, if I could just put it at the foot of page 801, he states the rule, the ipso facto rule, will never be recognised in Australia as operated as an assignment. There's the rule. English and Australian bankruptcy courts, while not recognising the foreign trustee's title to recover in his own name the bankrupt's lands, have long acted under these provisions to make available those lands to the foreign trustee so they can be realised for the benefit of the creditors of the foreign bankruptcy. Of course, the foreign sequestration orders claim to reach the local lands. In Re Greenway and Re Fogarty, we've looked at the latter, this was done by declaring the absent bankrupt a trustee of his local lands for his foreign assignee in bankruptcy, presumably on the basis that after bankruptcy, the bankrupt holds his property as trustee for his creditors, Galbraith and Grimshaw, and by then making an order under the Local Trustee Act vesting the lands in question in the foreign assignee. In neither case was the foreign decree, despite its terms, recognised as vesting title to the bankrupt's local lands in the foreign assignee. Nevertheless, this same result was achieved by the local court acting in aid under the Imperial Act. A different approach has been taken in other cases that achieves the same result of making local realty available to a foreign trustee for realisation and distribution in foreign bankruptcy, even though the local court will not recognise the foreign trustee's title to the land. So again, the ipso facto rule prevails. In Osborne, Osborne was declared bankrupt by the Manx Court. The Manx trustee obtained a letter of request, equivalent to Section 29 of the 1966 Act in Australia, seeking the aid of the English court in obtaining the bank's English property. He then applied to the English court for a declaration vesting in him all the bankrupt's English realty and personality, and in the alternative for his own appointment as receiver of all his English property, power to sell the same and make the proceeds available for distribution in the Manx bankruptcy. Mr Justice Falk did not consider it necessary to determine the domicile, refused to recognise the title conferred by the Manx sequestration order on the trustee to the bankrupt's English property, including the English land. That is the opposite of what was submitted by my learned friend. And the reason he refused is the ipso facto rule. As we know, he then went on to say, is there an alternative? And he followed Cooperman, which is a common law case. So, my lords, whichever of these cases one looks at, and if you look at Fogarty, or if you look at Bolton, and you've seen them both twice now, that case concept and that juridical approach to what is actually going on is happening in those cases. And in no case does the ipso facto rule get somehow abrogated or made an exception to, or in some way be ignored. Quite the contrary, it is the very rule which causes the need for assistance.
Why do we have the immovables rule then?
I'm so sorry?
Why is there the immovables rule then?
Well, precisely because it is for this court in this jurisdiction in relation to English real estate to decide who has title to that property. That is not what's being addressed here. When I mentioned, possibly a little bit too colourfully, the fact that in this case the Russian bankruptcy has not been airbrushed out, the fact that this property is a bankruptcy asset in Russia is a fact in the world. The immovables rule doesn't affect that either. The fact that Mr Bedzhamov is bankrupt in Russia and is registered with this property in this country, all of that, they're all facts in the world. The only function of the ipso facto rule is to say that, unlike an English trustee in this jurisdiction, I cannot simply say, it's not yours now, it's mine, it's vested in me as a matter of law. I can't say that. But I can say that you hold that property on trust for the creditors, as the authorities demonstrate. Mr Wilson has pointed out to me that within Dicey, which we find in tab 81, on page 1331, I think very much following on the question to me from my Lord Justice Stuart-Smith, I don't know whether you have on page 1331. First of all, at the top of the page, the rationale for the immovables rule, and this is obviously not in the context of necessarily bankruptcy, but generally, that's paragraph 23-063. Second sentence, based upon obvious considerations of convenience and expediency, any other rule would be ineffective because in the last resort land can only be dealt with in the manner which the lex situs allows. And then at the foot of the page, perhaps more relevantly, indirectly of course, a foreign immovables may be affected by a judgment of an English court in personam, ordering some personal subject to the control of the court to execute a conveyance or mortgage. And again, it's the same point. The ipso facto rule isn't affected because it is the title owner who is directed by the court to transfer.
The next sentence isn't so good for you.
Well, my lord, that is the Duke and Andler, of course, and
yes.
Your lord, we haven't had time for this, but your lordships have in their authorities bundles the case of Shamji, a decision of Mr Donaldson, Queen's Counsel, which is at tab 62, persuasively not following that reasoning from 1932 in Canada. And in fact, just for completeness, and I suppose for the record, for anyone interested in that particular debate, there is a very interesting article entitled "The Court's in personam jurisdiction in cases involving foreign land," which we've inserted at tab 93 of the authorities bundle, but I readily accept that I'm not setting lordship's homework, obviously.
Yeah.
So, my lord, I hope I did that very quickly, but I hope it you have from us our submission, which is very much radically different from learned friends' submissions, as to what the gateways are doing. Gateway, one of the methods identified by Lord Collins 426, you have some qualifications in order to get into the club, as it were. But once you're in, for the purposes of bankruptcy and immovables, you're in exactly the same position as you are at common law, without any exceptions, because of course the Insolvency Act of the foreign country or this country are not relevant. What is relevant is the assistance that can be given in equity for the reasons given by Lord Justice Morritt in Hughes and Hanover. Now, can I just address what my learned friend submitted in relation to rents and profits? I won't take long on this.
Yes, I mean, I do wonder whether, well, say what you have to say, but I do wonder whether that's a problem for another day.
Indeed, it is. But can I say no more than this? If my learned friend's submission is right, there would never be any justification for appointing a receiver over rents and profits. According to him, neither the rents nor the profits belong to the foreign trustee.
I mean, I can see all sorts of possible complications there.
That's his case. His case is that you have no right to the rents and the profits, in which case, why would you appoint a receiver?
Yes, I mean, there may be middle ground, I don't know. You say, well, you're entitled to the lot. He says you're not entitled to any of it. I don't know whether the bankruptcy law in the country in which the bankruptcy order is made may affect the position.
My lord, it does. Not in relation to rent, though, because rent, of course, comes out of the land, and whoever owns the land is entitled to rent.
I don't know. I mean, we're getting into territory that I suspect we don't need to go into.
No, fair enough. My lord, can I just say this? If your lordship goes to, this is on recoupment, just in response to what was said about recoupment. That is, in one sense, the fons et origo of the common law ability to give assistance. And it's the very short judgment of Mr Justice Asprey in that case. You've got our submissions that every article, every textbook, and any other case subsequently that has referred to it has either approved of recoupment or has not ever disapproved of it or cast any doubt on it. And of course, it's the basis upon which Rule 217 is set by Dicey. Could I just ask your lordships to note that behind tab 33 in the authorities bundle, you have the decision of Mr Justice Goulding in a case called Shemmer. And it's, in that case, it's perhaps, I'm permitted to observe that Mr Jeremiah Harman was leading Mr Hoffman on the one side and Mr Dillon was on the other side. And in his judgment, Mr Justice Goulding, page 287, letter between A and B, recited Cooperman as part of the authorities which were relevant to the question whether a foreign receiver should be appointed, should be recognised in this country. It's just another indication that in all of these cases, Cooperman has never been doubted. May I now address you briefly on this question of whether creditors could apply for a bankruptcy petition?
Yep.
Again, I'm sorry to sound strident, but we do respectfully substantially differ here with my friends in this way. One only has to make three propositions. The first is, there is no such thing as an ancillary bankruptcy.
Say that again once more.
There's no such thing as an ancillary bankruptcy in common law. Under our statutes, there's no such thing. Secondly, a second bankruptcy in a second jurisdiction is always, and I mean always, hostile to the first bankruptcy. Two different estates, two different sets of rules, two different sets of creditors. So in this case, if the bank should bankrupt in this jurisdiction Mr Bedzhamov, there will be a new class of creditors, new assets, and a competition of the worst type between two conflicting jurisdictions. It's the thing that modified universalism is pretty much designed to avoid. It's antipathetic to modified universalism. And the third proposition, of course, is that although at times he, I think, nearly came to suggest it, I don't think it is seriously suggested, and I hope you'll forgive me if he's not suggesting it at all, that in any event, my clients cannot petition for bankruptcy, even on that basis.
Well, that wasn't suggested. It was suggested, and it was my fault. I set that here running because I misspoke. So I apologise.
No,
when I referred to the trustee applying, I meant to say, of course, the creditors on the basis of whose petition the trustee did appoint.
I'm blushed. So
So
there's no
that's
question.
the question.
So the only question is whether there is another creditor who is not subsumed already in the bankruptcy in Russia. And I'm afraid my own friend's suggestion that in some way somebody who has already proved in Russia in the bankruptcy there can nevertheless start a fresh bankruptcy petition and proceedings in this country is not only contrary to authority, but you only have to think of the consequences. If a bankruptcy order were made on the same debt in respect of which the creditor has already submitted in Russia, he would be creating a conflicting and diametrically opposed parallel concurrent bankruptcy in a different jurisdiction. That is absurd.
And just to be clear, I think Mr. Robbins was quite careful to say there was no problem in terms of English law. You say it's contrary to authority. Is there English authority saying that you're right?
There's only English authority to the effect that that is the position in Russia. In other words, the same facts as ours, where you have a Russian bankrupt, that's Laptev, which we showed you, the whole fourth holding.
So there's no, in English law terms, there's no problem.
Well, no, there is, my lord, because you can't have a creditor creating a second competing bankruptcy against the first bankruptcy. That is a fundamental problem, which I'm not aware that anyone has ever suggested that could be done.
So is there any English authority saying it can't be done?
Well, my lord, no, because nobody, as far as I am aware, has ever attempted that, where you're already participating in one bankruptcy in Russia, and you want to create a new bankruptcy here with a new estate competing with the Russian estate.
I mean, there's no problem in terms of the Insolvency Act. You can meet all the conditions.
Well, that would, if the creditor in question, as a matter of, well, that goes back to Laptev. I mean, that's the point in Laptev.
Well, yeah. So it wouldn't work, would it? Because the way it would work is the creditor has proved in Russia, and if a petition is sought to be made on the basis of the same debt, the answer to it will be you've got no standing in this country because you're not a creditor because that debt has already been subject to the Russian process.
That is what Laptev holds.
Yeah, but that's applying Russian law.
It is.
But I suppose you have to apply Russian law to find out whether it's been compromised by virtue of the Russian insolvency.
My lord, you do. And that is what, that was the issue in Laptev. I think from memory it's the fourth holding. It speaks for itself, and that reflects the judgment in the law report. And so I may, just to summarise on this, that is to say, summarise our reply to Mr. Robbins' submissions on how the assistance works. There's no question here of incompatibility. He made some submissions about incompatibility. You may recall. He took you to HIH, and what he did is he showed a case where, under 426, the Lordships found that you could remit back to Australia, notwithstanding the fact that there was a different regime for distribution out there. And then he took you to comments that were made to the effect that only 2 of the 5 law lords suggested that it could have done it also at common law. And the others said, no, you can't have an incompatibility. If you can't do it under 426, you certainly can't do it at common law. That's the incompatibility point. Here, there's no suggestion of more than one gateway applying. The only gateway is the common law. And according to my learned friend's own submissions, if this were a 426 case, then you could certainly give assistance. And we say that for the very same reasons, the judge should have found that he had power to give assistance at common law. These points matter, my lords. I'm sorry to say that if this is the obvious. Because in cases not like this one, the bankrupt will not necessarily be present in the lex situs. And then, of course, this issue is front and centre, terribly important. In our case, we've got the fallback. We say, well, even if you don't like our other submissions, he is here, we are recognised, we are his trustee, and you can make an order against him in persona. But if he were not here, which is the vast majority of cases, and in a sense the usual case, then the question would arise just as a dry and arid question: can I appoint, in his absence, can I appoint a receiver? And can I make a vesting order?
You'd have to have a jurisdictional basis to do that.
You would, and the jurisdictional basis would be that he's submitted in Russia. You don't need to make an order against him personally. That's what normally happens in these cases. In Australia, the trustee turns up.
That's the more difficult case from your point of view. I mean, this case is actually more straightforward, precisely because Mr Bedzhamov is here. Therefore, the court has in persona jurisdiction, and therefore we don't have to worry about potential jurisdictional difficulties that might arise if he weren't.
Lord, I entirely agree with that. I just wanted to point out, and I'll move on, that, of course, when you're considering how all this works, in many cases, the bankrupt isn't in the jurisdiction. And that's really all I want to say. It's particularly relevant after Brexit.
I can see that, but I think that's a question for another day, isn't it?
Yep. Finally, my learned friend, Mr. Robbins, made some points to the effect that assistance should not be granted in a circumstance where Russia was not Mr. Bedzhamov's place of domicile. So he says, although I accept that submission to jurisdiction is a recognised rule, a means by which you can come to be recognised, you can nevertheless, when you're asking whether you should give assistance, take account of the fact that he was not resident in Russia at the time. And Miles, we have dealt with this in our skeleton argument. And we basically make the point. I'm just trying to find the paragraph. I'm sorry. It's paragraph 52. Thank you for 42. Yes, it's paragraph 42. We are here, in a sense, promoting our ground too, and this is our submission in support of ground two, but it addresses the same point. This submission of Mr. Robbins is borrowing from the judge's analysis, which is, we say, proceeds on a misconception about the concept of submission. And as you'll see in the middle of paragraph 42, there's no question here of jurisdiction hopping. But as far as recognition is concerned, you either submit or you don't. And any question of sufficient connection or domicile is of no relevance at all. And again, all of the textbooks and all of the authorities say as such, with no exception. My Lords, that was all I was planning to say by way of reply to Mr. Robbins. And as you'll appreciate, our principal submissions relate to the way in which he described the statutory exceptions to the ipso facto rule and the fact that no such exceptions exist, save for Scotland and Northern Ireland. But I now move on to my own friend's submissions, Mr. Fenwick's submissions, in relation to whether recognition should have been granted. You've got our skeleton arguments, which is behind tab 12. And we deal with the Russian claim, paragraphs 16 to 22, the VPB Russian claim, I'm sorry. Just looking at the structure, we deal with VTP 24's Russian claim between 23 and 27. And there is an overriding issue here, and it's a sort of whiff that in some way the trustee is acting as a hired guns, as we mentioned in our skeleton argument, or as a cat's paw. And those phrases, as you know, are taken from judgments in our jurisdiction where it has been alleged that in some way a trustee is acting for an abusive process or something of that nature. And in our skeleton arguments, we have set out at some length our submissions as to why what Ms Kireeva is doing is very different from what the bank is attempting to do, that there is not a community of interest. And in particular,
just interrupting you very briefly, in the light of earlier submissions, VPB's debt has been compromised, has it?
I'm sorry?
VPB's debt has been compromised, has it? Oh, this is a different debt.
Yes.
Yes, I see.
That's the point. It is a different debt, and if I could just on that.
And they're allowed to keep their powder dry in Russia, are they?
Lord, I'm sorry?
They're allowed not to put in a proof in respect of this debt in Russia.
Well, that I don't know. I'm sorry to say. It's not a point that's whether there is an obligation on a creditor. I mean, I would doubt it, but I can't.
I mean, normally when you have a bankruptcy order, either you prove, or that's that. The old debts are wiped out.
No, with respect to that, I think you can have separate debts, and you can choose which ones you want to prove and which ones not. That's your.
You
right.
can in this country, can you?
Yes.
A bankruptcy order is made. A particular creditor thinks he'd rather not claim in the bankruptcy. He'd
Yes.
prefer to bring proceedings independently. He can do that.
There'll be stay.
I'm sorry.
There'll be a stay.
I'm sorry.
There'll be a stay.
A stay. That's not really the. That's not the point. That's the difference, because that's in this jurisdiction. So what I'm addressing is whether, if you prove in this jurisdiction for debt A, you can sue for debt B in America, which is a different point. You may not.
Yeah, but in the eyes of this country, could you still pursue your debt in this country, or indeed anywhere else?
Well, you can pursue it in America, which is all that matters for me.
Well, you've just upset the only thing I ever thought I knew about insolvency.
I'm very sorry about that.
Yeah. Anyway, sorry.
So our case is very much that there are, and there is a lot of evidence about this which you have not been shown. There are two debts, no overlap. There's a tremendous factual dispute between the parties on that, and whilst we've given you the we've given you the references. And I'm not really sure how this court could ever get even into that debate. The evidence is, we say, clear one way, namely there are two debts, not one, and that the debt that's being sued for in this jurisdiction is not something that has been proved for in Russia.
I mean, the key question on Mr. Bedzhamov's appeal, as I understand it, is whether the VTB 24 debt is sufficiently clear. There, as I understand it, there's no real dispute about the law. You cite low-lying KEPAC and so on. So it's a question of whether what is now said by Mr. Bedzhamov is so incredible that it can be ignored.
Well, no, my lord, no. Because it's a different test. This is the dicey test as to whether you can set aside or otherwise overlook a foreign judgment on grounds of fraud, which is a very high bar, and the judge dealt with that. It's an exceptionally high bar. And what is being suggested, we would say with extraordinary insouciance, is that you can, on the third day of a hearing, at about midnight, send by email a witness statement which suggests that a document has been forged, and in that way cause a state trial to take place. And our case is that the VTB guarantee was signed, if it was signed, in October 2015. And it is a fact that the documents include, loan documents which are admitted, include reference to the fact that Mr. Bedzhamov himself was giving a guarantee. And, my lords, we know that there were proceedings in Russia, both at first instance and on appeal, based on that guarantee. We also know that as a result of the judgment that was obtained, VTB 24, unsurprisingly, petitioned in Russia for his bankruptcy. And for reasons best known to Mr. Bedzhamov, it would appear that from 2016, when he was being pursued in the courts for this guarantee, until 2020, September of this year, he never once asked to see...
This is all good jury stuff. But the question for us is whether the issue having been raised and the witness statement having gone in, the judge was right to conclude on the balance of probabilities that the judgment was secure.
Well, no, that wasn't the test. that he was being asked to
Well,
find that a foreign
I
judgment
agree,
was...
but it's a test that he did apply, because he said this evidence is not sufficient to satisfy me that
And then the
the
test.
judgment should be set aside.
Yes, it's a two-stage process. Does it have any weight at all? And if it does it satisfy the test which he sets out in his judgment? And first, he was correct to give it no weight at all, having regard to its genesis. As he says himself, and perhaps we should look at what he says in the judgment, it was only as a result of his own intervention on the Friday that they went away. It's paragraph 163. So on the Friday the 16th of April was, the judge raised the point that he had no evidence at all from Mr Bedzhamov, even alleging that there was a forgery. That caused late, very, very late, on Sunday evening before the third day of the three, the statement to be served by email, which we read the first time at about 9:30 on the Monday morning, sorry. And at that stage, the judge was perfectly entitled to say, and it was a matter of his discretion, I am giving this no weight at all. If you look at the evidence, it doesn't say anything about the circumstances in which he gave the loan. It doesn't say anything at all about the circumstances in which he gave the security, or why he gave the security.
But that's not what he said. He said at 165, I do not accept that Mr Bedzhamov's evidence is sufficiently strong to demonstrate that any of the bars to common law recognition apply. He didn't say, I'm giving this no weight at all. You didn't object to the evidence going in for reasons which we don't need to go into, but you didn't. The evidence was in, and the question then was what to do.
Well, my lord,
He could, I would be the first to accept that he could have said, this is far too late, I'm not having it.
my lord, there is. I think the point I'm making is that he was having to deal with Rule 50 of Dicey, and he was being asked to apply Rule 50 of Dicey, effectively to find that there had been a judgment obtained in Russia by fraud. And this evidence went nowhere near
I think what
even
he was being
starting that
I
process.
thought what was being submitted to him was that he couldn't determine whether the evidence was sound simply by looking at it.
Well, my lord, I think one has to recognise, first and foremost, that this was an application which, in respect of which directions had been given, evidence was in, more evidence was served, still more evidence was served before the hearing, and it was only on the second of 3 days the judge said, I've got
I
nothing.
have every sympathy with you about the lateness.
And so it is, the question is, did the judge err in principle by saying, I really can't give this any weight? And the answer is, he could easily have said, I'm giving this no weight at all. You have had 5 years to produce this.
He didn't say that.
Well, my lord, he was generous.
He said, but the trouble is, we have to approach his judgment by what he said.
My lord,
Whether,
my lord, I accept
whether he
that.
was being generous or not. The question is whether the reasons he gave are sufficient.
And they are, my lord, if I may say so. I mean, he's simply saying, in 163, nothing at all had been adduced. I drew it to the attention of counsel. Then a witness statement was produced towards the end of the hearing, prepared overnight. And then he goes into that evidence. And of course, he has to weigh it against that context. And he's entitled to say, it's not sufficiently strong to demonstrate that any of the bars to common law recognition apply. And I would respectfully suggest that must be right.
Can I just go back a stage? I must admit, I hadn't got properly in mind the terms of your respective skeletons. So I had the impression it was common ground what the legal test was, but it obviously isn't common ground. So Mr Bedzhamov says, well, you apply the Keep Act low line winding up petition type test, and you can't go behind what has been said in witness evidence unless it's obviously wrong, broadly. And I take it from what you're saying that you don't accept that. So what do you say the test is?
My Lord, what Mr Justice Snowden was doing, we see at paragraphs 132, where he refers to the well-established grounds.
But that's the legal point.
Yes.
In order to stop recognition, you have to show fraud.
Yes.
But that's common ground. The question here is a factual one. Is it the case that Mr Bedzhamov's signature was forged on this document? Now, in determining that factual question, what is the test that is to be applied?
Well, the test is, can he place any weight on that evidence given the circumstances in which it is produced?
And
In other words, is that evidence incredible?
But, my Lord, so long as that's qualified by including the fact that it has taken 5 years for it to be produced, that's not, so it's not just, as it were,
No, you don't just read it and say, well, there are the words.
the context doesn't include just what happened at the time when the alleged forgery is said to have taken place.
I mean, I absolutely follow that. In the context of, say, a disputed winding up petition or whatever, you don't just look at the words, you look at the context, you take into account the fact that it's taken 5 years to raise the point
Yes.
or whatever. But the legal test is that we see running through the cases cited in Mr Fenwick's skeleton argument. Now, do you disagree with that legal test?
I do not, so long as it is accepted that on the facts of this case, the circumstances in which this document was produced when it was obviously highly relevant to assessing credibility of.
And I quite follow that. Just one follow-on. The judge didn't obviously apply that test. Do you accept that?
Well, it's difficult to say that he didn't. He was being generous to them by saying that he just didn't feel that it was a make weight. It wasn't strong enough. I don't think it's right to say that he didn't appreciate the test in the vanilla sort of disqualification type cases where you have a trial.
Is there any indication in what he says that he is looking at it that way rather than, say, 168, where he talks about whether the evidence is sufficient to establish fraud on the balance of probabilities, which is a different test,
Well,
on the face of it?
I mean, it is difficult in this sense. This was always going to be a hearing on paper, as we used to call it. There were no directions for live witnesses, and had there been directions for live witnesses, there would have had to be directions for interpreters. And the whole thing would have taken on a completely different complexion. So on the 5th of March, it was agreed there was going to be a hearing of the recognition application. Directions were given, those were complied with. And they were on the basis that it was a paper application, very much as it might have been any insolvency application or indeed a judicial review application. You get disputes of evidence, you have to take them on in your stride. This is not a trial.
You don't always take them in your stride, even in jail.
I accept that.
You
Not
don't
always. Of course I accept that. But this is a case where they are seeking to suggest that this court should disregard a foreign judgment on grounds of fraud. And Mr Justice Snowden is entitled to say, my goodness me, if you are really going to try to persuade me that your signature was a forgery, you do not do that by raising it for the first time on the eve of the third day. It's not even in your skeleton argument. It wasn't in your written openings, it wasn't in your oral openings, and it's only arisen because I've given you a bit of a hard time on day 2 as to how on earth am I supposed to deal with this. In those circumstances, the judge was entitled to say, I simply don't find this credible. This debt is the debt on which you were made bankrupt in Russia, and you contest the Russian bankruptcy, but you have never once written to anyone to suggest that the debt is in some way bogus, fraudulent, void.
I mean, one trouble is he never does say that.
I'm
I don't
sorry,
think he ever does say, I simply don't find this credible.
Oh, the judge?
Yes.
Well, I think the judge isn't... When reading his judgments, one must take into account the fact that he plainly thought that the manner in which this had been produced at the last minute as a new point, which was not being advanced up until that time, not a point before him. Enough is enough. We're not gullible, and I'm not having this. The object of the exercise, obviously, when one is exchanging evidence on an application such as this, it is to make sure that your points are covered by your factual evidence. And this, if this is the only point that they had to demonstrate that there's something colourable about the VTB 24 debt in Russia, it beggars belief that it didn't come out until the judge prompted them at the end of day 2, showing them they didn't have a case in relation to forgery. And I'm reminded by Mr Wilson that on the 12th of April they served a very long reply statement to our evidence. No mention at all of forgery in there. And that would explain, of course, why there was no mention in the skeleton argument. And it would be highly surprising if a person in the position of Mr Bedzhamov, leading and judging counsel, city firm of solicitors, on the eve of the last day, can disrupt everything by producing a statement of that nature. It was just not his case, and Mr Justice Snowden was entitled to see it that way.
We were told, and I assume it's correct, that there was no objection to this very late evidence being admitted.
My Lord, that is correct. I think I was on my feet, and we just took it in our stride. We, for what it's worth, we took the view that it was just too late to start running a completely different case, which had not been the subject of submissions.
Well, that would have been a perfectly rational basis for you to object to the evidence being admitted. There we go. You didn't. And understand. Thank you.
Obliged.
I mean, anyway, whatever the judge said, you say it's just not credible.
We do.
Yeah.
And the point, I think I'm probably just repeating myself now, but it is important to see in context quite how extraordinary this last chance is, given the history of this case, and that we have set out in our skeleton argument. Sorry, forgive me, I'm just briefly also reminded that the point about not being able to afford an expert, quite apart from the remarkable funds that that Mr Bedzhamov has had at his disposal, I am responding now to the suggestion that by now, by that I mean March, April 2015, my own friend's client had no access to money. My Lords, just for the record...
Sorry, you must mean 2021.
Oh, did I say 2020? I'm sorry, I meant 2021.
Yeah.
Just for the record, on the 5th of November 2021, my learned friends, instructing solicitors, served the 10th witness statement of Mr Bedzhamov, in which he identified 9 loans that he's made, in taken the benefit of in 2021, for a total sum of £300,000. The first loan was in March of 2021 for some £128,000, out of which he paid his chauffeur, the nanny, and the maintenance on the Bentley.
9 loans, total value?
The total value of the 9 loans, 300,000, and he itemises in that witness statement, the 10th witness statement, the destination of the monies, and the first 128,000, which in the zone March 2021 went to the chauffeur, the nanny, and the maintenance on the Bentley. with a suggestion that he thought that was more important than instructing an expert to look at his handwriting on a guarantee which he says he maintains is a forgery. It is incredible. My lords, I've gone past my allotted time. I've noticed we're into the lunch hour. I'm in your lordship's hands because we have overrun.
Yes. You're coming up to your 1 1/4 hours.
Yes, I am, and subject to taking instructions, I was going to sit down.
In which case, what I think we might do, assuming Mr. Fenwick has very little to say in reply, as I'm hoping, we might sit on into the lunch hour and bring matters to a conclusion.
Well, unless you have any questions of me, those are my submissions.
Thank you very much, Mr. Davis. Mr. Fenwick.
No, I'll indeed be very brief. I have 5 short points, and I think Mr. Robbins has 2 points on some of the new authorities. Lord, much of what you've been told in the last few minutes by learned friend is simply wrong about how the question of forgery was brought up at the last minute. It was not. The first witness statement of Mr. Belchick, served on the 23rd of March, said in terms, that's S571, paragraph 49, that it was defended on the grounds, on instructions, that it was a forgery. There was a further hearing, which where Mr. Bedzhamov was ordered to attend in person to be tested, he didn't. So the question of forgery was not raised at the last minute. It had been raised in advance. It was my written submissions made clear that we thought the matter would have to be determined with directions and evidence, including expert evidence. As an old friend said, there were to be no live witnesses. That was because we were essentially dealing with a question of law. The point being made, we have the right to Belgrave Square. If we had wished to deal with it at that stage in a proper way to challenge it, then inevitably the urgent hearing would have gone off beyond April into May, June, July, August. The sale would have been lost. The purpose would have been of no avail. So what we did was to say, let's have a hearing on the law. Let's show that it's an immovable, that he can't have it, and either strike out his application, her application of recognition now, or make directions. That was perfectly proper in the circumstances. Next point. Learned friend says there were 2 debts. In one sense there were, in one sense there weren't. As I've shown you by the schedule, which Lord Justice Stuart-Smith found as difficult as I did to read, what there were 42 alleged loan agreements. The case in these proceedings is that some of the credits to those loans were false, and therefore that the amount owing was larger. The fact that the unjust enrichment proceeded only on the balance after deduction of the alleged payments doesn't make them different loans. It makes them part of the same loans, where their case must be that had they known or believed them to be fictitious credits at the time they issued the unjust enrichment proceedings, they would have included. So, Lord, the fourth point I want to make is this, is that if your lordships are minded in any way to continue either recognition or to adjourn the matter of recognition for a further hearing, it should be on terms that my client is still entitled to spend money in accordance with the worldwide freezing order, since otherwise he will not be able to defend these proceedings, or indeed be able to defend proceedings in relation to VTB 24. My final point is this, and thinking of what my Lord Justice Arnold was saying about the VTB 24 debt. Of course, that is relatively small. This battle is not about the £4 million of VTB 24. It's about a claim for 1.3 billion and a trustee's claim for 30 million for VPB for the unjust enrichment. So it may be that the correct approach is to leave the case management to Mrs Justice Falk to decide when that issue should be determined and what protection there should be by way of ring fencing of the proceeds of sale in order to protect VTB 24 as a creditor. Lord, that was all I wanted to say.
Thank you very much. Mr Robbins,
Hello.
you want to reply on new cases?
Yes, just two short points. First, your lordships were given a very short extract from Dicey Rule 215. It's a very abbreviated treatment. The reason for that, your lordships will find in paragraph 31070, which says, speaking generally, the statements made in the comment on Rule 211 with regard to the effect of an English bankruptcy as an assignment apply with the necessary alterations to the effect of a Scottish or Northern Irish bankruptcy as an assignment. So it's abbreviated because it's simply referring back to what's said.
And the paragraph number was 31.
070. Can I just hand up Rule 211, which deals with that converse position? So this is dealing with an English bankruptcy and land in Scotland or Northern Ireland. Could I ask your lordship to read paragraph 31034? So even when dealing with land in Scotland or Northern Ireland, the way for an English trustee in bankruptcy to get at it is through subsections 4 and 5 of section 426. And it's in that sense that section 426 operates as an exception to the Immovables rule, in the sense that it is capable of producing an outcome which is the opposite of the outcome that would otherwise be achieved. The other point relates to my Lord Justice Arnold's question about the ability of creditors who've proved in the foreign bankruptcy proceedings to petition in England. And it does raise an interesting point. As a matter of English law, if a creditor submits to a foreign bankruptcy court's jurisdiction by filing a proof of debt, and there is a discharge of the debts under the foreign bankruptcy law, then English law will recognise the effect of that discharge, and you may well end up in a situation where all the creditors proved in the foreign bankruptcy and their claims have been discharged, and they're therefore unable to petition in England. That's not the position in the present case. My lords may remember, and just to have it open, it's at A318. Mr Phillipson, on behalf of VPB, said that under Russian law, he cited the relevant provisions at the top
Sorry,
of the
can you
page.
give me the reference again?
My lord, it's A318. At the top of the page, he cited certain provisions of Russian law and said that certain liabilities remain undischarged by the by the Russian bankruptcy proceedings. Just in England, as we have an exception for fraud claims, we don't discharge fraud claims, even if the creditor proves and receives a dividend that can be pursued subsequently. And what Mr Phillipson said is, in 477, as a matter of Russian law, GB will not, upon completion of the relevant stage of his Russian bankruptcy, be released from his liabilities to the bank. The bankruptcy would not prevent GB, I think there must be a typo, for VPB, from pursuing such claims against him in these proceedings. So VPB's own expert evidence in support of the application for the WFO was that discharge in Russian bankruptcy wouldn't discharge its claim, which it could continue to pursue.
That's because it's a different debt. I
In
mean,
England.
what they're saying is they've compromised their unjust enrichment claim in Russia, and that could not be relied upon to found a petition in this country, whereas they're saying, as you rightly say under our law, if it's a fraud claim, different claim, not discharged, and that can be relied on. Isn't that what they're saying?
Well, yes, what they're saying is that there are certain liabilities which remain undischarged. That's paragraph 2 at the top of the page.
Yeah.
And they refer to controlling personal liability and tort liability. And so they say it won't be discharged, they can continue to pursue it.
But the tort liability is the fraud claim.
Exactly. Mr. Fenwick reminds me that the VPB also said that its reasons for not seeking enforcement of the unjust enrichment judgment in this jurisdiction, which it disclosed in the full and frank section of the WFA affidavit, were the contents of the DIA report and the conclusions that at least 2 billion rubles of those loans were fictitious.
Well, to be sure, and that's why a better way of testing it is to think about VTB. So could VTB petition in this country for the self-same debt that it's proved in Russia?
If it's proved and the debt has been discharged as a matter of Russian law, then English law would recognise that discharge.
Exactly.
But as I say, VPB's case is that if it gets a judgment in the claim in the High Court in England,
Because
that
it's
judgment-
unreleased by
it
Russian law.
hasn't been released, and then it could petition for bankruptcy in England.
Yeah.
So unless you're have any questions.
Mr. Davies, you must be entitled to reply to Mr. Robbins on those points.
I'll be frank about this. I'm not sure this is a reply, but I have received a message that given the concertinaed nature of this morning's proceedings, there is one point which I suspect your lordships have well in mind that I ought to bring to your attention. And it's that's paragraph 18 of our respondent skeleton argument behind tab 13 of the core bundle. Reminds your lordships that there are presently 3 more claims waiting in the wings in the bankruptcy in Russia for an aggregate sum of some 50 million. And you'll see in paragraph 18 the reference to the evidence where you can see more details of that. And that's a typical, I suspect, trustee wanting the court to know more about the numbers than the law.
Mr. Fenwick, I think you're entitled to the last word on that, but there's probably nothing more to be said.
Only they haven't been proved, they haven't been admitted. They all arise out of the conduct of the destruction of Mr Bedzhamov's businesses, and they shouldn't affect the Lordship's judgment.
In which case that does conclude the hearing. Thank you all very much for your submissions. As you would expect, we're not going to deliver a judgment now. Judgment will be reserved. In the normal way, you will be provided with a draft for you to correct our typing and grammar, but not to re-argue the case. I think in accordance with current practice, judgment will be handed down remotely, but even were it to be handed down in court, there would, of course, be no need for anyone to attend. As again you'd expect, we'd be grateful if, in advance of the hand down, you'd seek to agree an order dealing with consequential matters. Should there be points on which you can't reach agreement, we'd be grateful for brief written submissions, and we would expect to dispose of those points in the order that we make. But thank you again for your submissions.